stop shirt for me. Okay. Go and put that paper off the top for me. Go and shut that for me. Don't fucking move! Don't fucking move!
Now, in today's video, we're going to be talking about a Supreme Court decision that got handed down about a month ago, and it got very little play within the Second Amendment community. It's not a case about guns per se, but it does have some interesting implications as it relates to the use of force. Specifically, I'm talking about the case of Felix v. Barnes. Now, this particular case, in and of itself, is somewhat unique. The Supreme Court typically does not like to hear what are referred to as interlocutory appeals. Essentially, a decision to review a motion to dismiss or some other type of motion that has happened during the pendency of the trial. But in this case, the Supreme Court did, and they reversed both the trial court and the Fifth Circuit Court of Appeals in what is referred to as the moment of force. And let me explain sort of how this potentially could affect us as civilians and those of us who seek to bear arms. Now, in this particular case, an individual was pulled over by a law enforcement officer in Texas. During the traffic stop, the individual decided that it was time to flee. And as he put his foot on the gas and began to drive forward, the law enforcement officer jumped on the running board of this individual's car. This was actually on a freeway, and the entire thing is filmed on the law enforcement officer's dash cam video. As the car was driving away with the officer attached to it, the officer, fearing for his life, drew his firearm and ultimately fatally shot the driver. Well, the individual's family sued the law enforcement officer as well as the department, claiming that there had been a violation of this individual's civil rights. Now, the trial court dismissed it, saying that a reasonable officer would fear for his life at the moment of the shooting. The appellate court upheld that dismissal, but then this was ultimately appealed to the United States Supreme Court. And this is somewhat interesting, in a unanimous decision, all 9 justices completely agreed. They said that the standard of review that both the trial court as well as the appellate court used the moment that force was used was inappropriate. In reality, the courts should have looked at the totality of the event, essentially opining that if the court had used this sort of totality of circumstances approach, they would have seen that the actions of the officer in jumping onto the running board were in and of themselves a unique situation that put the officer at risk that they did not have to assume. After all, the individual did not represent an imminent danger to society. There was no evidence, at least nothing that was presented, to suggest that the individual was a threat to a specific individual. Rather, the officer was simply trying to effectuate an arrest and put himself in a level of danger that was, candidly, as the court sort of opines, unreasonable. Now, Justice Kavanaugh, along with a concurrence by Justice Alito and Justice Thomas, they sort of discuss how dangerous traffic stops are, and they sort of suggest that it is entirely possible that the officer's conduct was, in fact, reasonable. But the test that was being used by the courts was inappropriate. Now, this is kind of interesting for a couple of different factors. First and foremost, it's the way that our system of evidence works in the United States. We have what is referred to as an adversarial system, meaning that you've got two sides that are essentially trying to combat each other and using the admission of evidence to prove their point. Whenever there is a trial, there are evidentiary hearings that take place prior to the trial even beginning. All right, guys, I'm going to pause this video for just a second. USCCA, which is sponsoring this video, well, they're doing a giveaway right now. And it's a pretty exciting one, and it's something you're going to want to participate in. You're going to want to get on it right away. You can read all about it in the description directly below this video, but as I said, it ends, so you're going to want to jump on now. All right, thank you, and let's get back to the video. During those evidentiary hearings, one side is trying to introduce evidence into the court. The other side is trying to keep that evidence from being introduced. And if you are successful in having your opponent's evidence restricted so much that it is virtually impossible for them to be able to prove their case, then by definition, you ultimately win. If that is unsuccessful to completely eliminate that evidence, at a bare minimum, you want to reduce the amount of evidence that comes on in so it makes your opponent's case that much more difficult to prove. And of course, they're doing the exact same thing to you. And there are a lot of evidentiary battles that take place, and there are tests that the court will use to determine whether or not evidence should in fact be introduced in the first place. Now, in this particular case, and what really has been somewhat doctrinal for a long amount of time, was that in officer-involved shootings, we look at the moment that the threat occurred. We do not look at the evidence that would have led up to that. Now, to contrast our system of jurisprudence with, say, a European system that uses what is referred to as an inquisitorial system, well, that is completely different. In an inquisitorial system, all the evidence comes on in. Evidence that may or may not even necessarily be relevant, but that evidence is presented before a jury, and both sides effectively have the opportunity to sort of explain why that evidence should bear more weight or less weight, and ultimately it's up to the jury's conclusion. This case effectively gives somewhat of a movement in the direction of the European inquisitorial system. And a lot of people in the United States, I think, will find this to be somewhat refreshing. After all, we've seen numerous instances where evidence that really shows a level of guilt or alternatively a level of complete innocence is oftentimes precluded from going before a jury. And it's inherently frustrating, especially for people who aren't lawyers, looking at this saying, well, this should be clear and obvious. Why is this being kept from the jury? But it's because of not only our evidentiary rules, but the different tests that we use to determine the admissibility of evidence. In this particular case, the court is saying, look, you can't look just at that moment of threat. You need to look at the entire totality. Were the officer's actions reasonable in the first place in getting onto that running board? Now, they don't come to an ultimate conclusion, obviously. That is for the lower courts to decide. So they remand this back to the lower courts using this sort of totality of circumstances test to then determine whether or not the case should be dismissed in the first place. And it is entirely probable that the court, looking at the totality of the circumstances, will say, fine, we're not going to dismiss the case. We're going to allow it to go to trial. Now, whether or not the plaintiffs ultimately prevail, that remains to be seen. But at a bare minimum, the jury should be entitled to listen to this evidence to begin with and determine whether or not the officer's actions were reasonable. Now, how this relates to civilians is also interesting. Obviously, this was a law enforcement context, but in a civilian context, we are often trying to get the totality of the circumstances introduced into evidence. And to be quite candid with you, usually we are quite successful. And the reason for this is fairly obvious. If a civilian is arguing that they felt that there was an imminent likelihood of death or great bodily injury, the only way to prove that information up is to give the totality of the event. After all, if someone was trying to kill you with a knife and they had, say, 6 feet earlier, dropped the knife, but it was too difficult for you to see that the knife had in fact been dropped, and then you used deadly force, and the government made the argument, well, at the moment that you shot, he wasn't armed, and there was no reasonable belief that there was an imminent likelihood of death or great bodily injury. You have the ability to sit there and say, because of the lighting, because of the way the geography was laid out, the fact that he had already displayed the knife and threatened to kill me to begin with, this all led to me believing that he still had this animus, and frankly, I still thought he was armed. This is typically allowed in at a trial court level. When it comes into a law enforcement context, it becomes a little bit more problematic. But in this particular context, looking at the Supreme Court's decision, this theory, this idea of bringing in all this evidence now becomes far more palatable. And the probability that individuals that have been charged with criminal conduct by district attorneys now will be able to cite this case of Felix v. Barnes as a means of trying to introduce potentially exculpatory evidence, even if that evidence does not necessarily relate to that moment of threat. This is a broad expansion on the defenses that now become available to us. This is, in my opinion, obviously as a defense attorney, quite a good thing. This gives us an opportunity to be able to persuade a jury with a robust level of evidence to suggest that the client's behavior was entirely reasonable when faced with this threat. Anyways, it's a good case. I definitely recommend that you look it up. Again, it's Felix v. Barnes. We'll see how this ultimately plays itself out. Guys, thank you so much for watching this video. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.